Your Honor, this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone.
Welcome to the Sovereign Citizen Files, and today's case might just redefine courtroom chaos. Meet Mr. Valentine, a self-proclaimed living man who insists he's not bound by the same laws as the rest of us. He's standing before the judge, facing DUI charges, and has decided to represent himself, rejecting not just his public defender, but the entire legal system. What unfolds is part legal train wreck, part linguistic gymnastics. Over the next few hearings, you'll see Valentine challenge jurisdiction, redefine words like person, and even accuse the court of violating his fee schedule. The judge? Calm. Measured. Possibly questioning her life choices. But that's not even the half of it. His family shows up later, his motions get messier, and his grasp on reality, well, let's just say it gets creative. Around because by the end, we'll unpack how these sovereign citizen arguments fall apart under real law, what judges actually think of them, and why representing yourself can turn a misdemeanor mess into a full-blown legal disaster.
See what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asked that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct. And
were these, one, it appears, was an allegation of a breast sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about 30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce.
Where Valentine's logic takes its first nosedive. He invokes something called Rule Nisi, which, in actual legal terms, is a judge's order that takes effect later, not a magical self-activation spell for defendants. The irony? By trying to implement a court rule himself, he's admitting the court has jurisdiction in the first place. These sovereign citizen tactics rely on pseudo-legal buzzwords strung together like courtroom fanfiction. It's performative, not persuasive. But it's also fascinating because these claims often stem from genuine mistrust of government institutions. The tragedy is that they lead defendants to sabotage their own defense while believing they're asserting
Offend and a risk to commit, another DUI or vehicular assault or homicide, given the history, while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm a seri juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona?
And here's the moment reality meets paperwork. The judge calmly lays down the law, $30,000 total bail, conditions for sobriety, and clear expectations. It's a masterclass in judicial patience. Notice how she doesn't rise to the bait when Valentine challenges her authority, she simply moves forward by the book. That's courtroom discipline. Sovereign citizen defendants often expect confrontation. When they don't get it, their arguments lose power. Instead of drama, they face the slow grind of due process. You can see Valentine's confusion, his beliefs don't fit the system, but the system doesn't bend for
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the facts, ma'am.
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
One attorney.
So we'll be back on September 20th. and you need to be back in court. If you're still in custody, we'll hear you in custody.
Can we
And
change
if
the
you
venue?
do post bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I
To
could.
deny the right to defend myself. You want me to hire someone else to do it? I'm of sound
I'm
mind and
not
body.
denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel and talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. All right, so we're done today, and those orders will be given to you.
Is sovereign logic in its purest form, the idea that if you deny being a person, laws don't apply to you. Unfortunately, courts don't operate on word games. You're a person in the legal sense because laws protect and regulate human beings. The judge's response, "I think you're a human being," might sound simple, but it's profound. It reminds us that law isn't a philosophical debate, it's a framework that ensures accountability. If Valentine truly weren't a person, he couldn't own property, hold rights, or even defend himself in court. You can't reject legal identity and still expect legal protection.
You by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah,
I'd like to-
hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have
Okay,
advised.
well, okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions?
Pleads with you not to represent yourself, take the hint. This isn't intimidation, it's experience talking. Judges see hundreds of self-represented defendants, and 9 times out of 10, it doesn't end well. Valentine's paranoia, seeing guidance as color of law intimidation, shows a deeper misunderstanding. The judge is actually offering him a lifeline, but he interprets it as a threat. It's the tragedy of sovereign citizen logic. When authority tries to help, they assume it's control. And here's a fun fact, even lawyers say, a man who represents himself has a fool for a client. Valentine's proving that old saying in real time.
That status, otherwise we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you. It was why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion here.
The great sovereign citizen contradiction, rejecting personhood while quoting "we the people." The U.S. Constitution is a collective legal contract, meaning, to claim its rights, you're agreeing you're part of that system. It's like saying you're quitting your job but still expecting the paycheck. The moment Valentine invokes "we the people," he reaffirms the very jurisdiction he's trying to escape. You can't cherry-pick the parts of law that suit your argument and reject the rest. That's not sovereignty, that's selective
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay, I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court, a motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court, and I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony, to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether
The full circle irony, Valentine, the man who swore off all government contracts, now wants taxpayer-funded help for his defense. It's a classic contradiction, rejecting the system's legitimacy until it offers benefits. It's a reminder that you can't be sovereign on Monday and subsidized on Friday. In the legal world, consistency matters. The moment you file a motion, you're participating in the system you claim doesn't apply to you. And that's the real catch-22 of sovereign citizenship. To challenge the system, you must first acknowledge its authority.
Since the last hearing is what I was looking at. So there was,
Yeah, I objected to his denial of those motions as well, because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
so what I reviewed is what was filed after the 18th. And that was October 21st. I have a request to release you and your request, I'll go back, let me get back to your court to dismiss these charges, motion to release you. And that's what I reviewed. So is there something else pending that I was not aware of after the 18th?
on this October 18th, there's one that says in Laserfish.
And that's where we'll leave Mr. Valentine, still fighting for his sovereign status, still tangled in pseudo-legal jargon, and still missing the point that courts don't operate on consent forms or self-declared immunity. What's most striking here isn't the legal confusion, it's the patience of the judges, who maintain composure while navigating what feels like a constitutional word salad. At the end of the day, the law is consistent, everyone is accountable under it, regardless of what terminology you prefer. Representing yourself might sound empowering, but as this case shows, it often turns a defense into a disaster. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns and sovereign citizen showdown.